For immigration law,
speak to Tan Law Solicitors.
for family law,
Speak to Tan Law Solicitors.
for employment law,
Speak to Tan Law Solicitors.
for wills and probate.
Speak to Tan Law Solicitors. At Tan Law Solicitors, we are on your side. Our proficient lawyers offer a range of legal services for both individuals and businesses. Book your 15-minute free consultation and mention the word radio. Visit tanlaw.co.uk.
Good evening, everyone. My name is Andrew Nyamayaro. I'm a solicitor at Tan Law Solicitors, and today we are here to discuss immigration and a bit of employment law. So if you have got any questions that you want us to discuss in terms of immigration, you can put them in the chat and I'll be able to assist in answering those questions. So if you've got any questions for immigration or a bit of employment, I can be able to respond to those questions. And I think, let me start with employment. I know that a lot of people are asking about the drivers, that the driver visa, the lorry driver visa. I've received a lot of questions regarding the lorry driver visa. I'll respond to that in a moment regarding the lorry driver visa. But as most of us would know, the UK entered into Brexit and left the European Union end of last year. And from last year up until June, it was the cooling off period, or rather the transitional period between the United Kingdom and Europe. So as a result of United Kingdom leaving Europe, I think this is one of the consequences that we are seeing, that UK is starting to experience some problems as a stand-alone country. I think it is a self-made, a self-inflicted problem by the United Kingdom, in the sense that we left the European Union and now it has come to haunt us. So there is now the issue of things that are happening, including the shortage of haulage drivers, the shortage of agricultural seasonal workers, and Europeans that have left and went back to their own home countries and didn't come back because they cannot be bothered to apply for a visa to come to the United Kingdom. Another thing that has been happening is that because of COVID, there's been a restriction of movement. There's been lockdown, and there's been restrictions that have been in place, and some experienced people across the board. It could have been in so many fields: the legal field, medical field, so many different fields. Some experienced people have left their professions, some have retired, some went into isolation, some decided just to leave, and unfortunately some passed away due to COVID as well. So there is a combination of reasons why maybe there could be a difficult situation that is existing as it is at the moment. Linked to COVID is also the issue of employment. As you would know, in the United Kingdom, there was the furlough payments that was being done by the government. But now, this month, September 2021, is the last month when the furlough is in existence. So from next month, furlough will be gone. So we are yet again to see what's going to happen, whether companies or employers are still going to continue to keep their employees, or they are going to make them redundant, or they are going to make some settlement agreements with their employees. So when it comes to issues relating to employment, we are experienced and we've got staff that deal with that. If you are going to go on redundance, the process of redundance, the process of settlement agreement, we have assisted a lot of clients when it comes to settlement agreements, to see if it's fair on you, if you're getting a payment that is meaningful to your circumstances, whether the terms and conditions are not so restrictive, because there will be some restrictions clauses in there, whether you're going to get a fair reference and things like that. So we also assist our clients with settlement agreements and redundant issues. So with the issue of the haulage drivers or lorry drivers, we are aware, as most people are, that the government announced a few days ago that they are going to introduce a visa for lorry drivers, and the visa will be valid for 3.5 months or some 3 or so months, because the drivers are supposed to leave the country on Christmas Eve. I think this is a poor decision, in my view, by the government, because even after Christmas Eve, drivers will still be required and needed. So I'm not so sure why the government thinks that after Christmas Eve, maybe they're just thinking about Christmas shopping. But it's not only about that. We have now experienced people queuing at petrol and fuel forecourts because people are panic buying fuel, because there's a shortage of those drivers who can drive the trucks for fuel. So while that can be blamed on maybe panic buying, which is a habit that people have when things don't go right, I think it is still a poor decision on the government, and also because as a result of Brexit. So the questions that I've been getting from people, it's all over the country. I've received questions from people in South Africa, Zimbabwe, Malawi, Pakistani, India, and so forth. I'm receiving a lot of questions and about this haulage driver visa. It's a visa that will be granted until Christmas Eve if the government does not change their statement on it. I have been looking out, and so have been colleagues have been looking out on what the government is going to say or put out as a guidance or maybe an appendix in the immigration rules. But as of now, today being the 29th of September, the government has not given the flesh to the skeleton. They've just told us that there is going to be a special visa for the haulage drivers, which may be considered as a low-skilled job, but it's still on the shortage. I think that it's going to come under the the points-based system. Maybe the employers might be required to have a sponsor license, or maybe there's going to be a new provision altogether relating to this type of visa. Maybe the employers might not necessarily be required to have a sponsor license, but we do not know at the moment. We do not know how exactly it's going to operate. But internally, the government, what they've done is that they have kind of relaxed the training process of haulage drivers. And they are also writing about 1 million letters to retired haulage drivers so that they can come back into work. And some type of licenses that you had to be tested, like if you're going to tow a caravan or a trailer, you will not necessarily need to do that license test anymore. So they are trying to simplify the testing system, hopefully trying to entice and encourage few other drivers to become haulage drivers. They hope that maybe they might get more than 4,000 drivers from relaxing the rules. So that is it with the haulage drivers or lorry drivers. The situation is not yet clear. We do not know what the government is going to do about it, apart from the fact that they have announced that they are going to have this visa in place for lorry drivers. Okay, so specifically to in answering the questions that you have put in the chat, one of the questions that I have is that how do you apply for workers if you have um, the license? So I want to anticipate that that's a question relating to an employer who has got a sponsor license and wants to apply for workers to come and work for that employer in the United Kingdom. If you have a sponsor license, you can, through your system, apply for sponsor certificates for your employees. Sometimes you might have just been given a sponsor license, which does not necessarily mention the number of licenses that certificates that you have. You might, through the system, you can generate that, and you can generate each sponsor certificate, which you will then issue out to your prospective employees or candidates. Once you have issued it to them, then either yourself as the employer or that candidate can then make a visa application using that sponsor certificate that you would have generated. It will be for the applicant whom you have given the job, and that applicant is also allowed to come to the United Kingdom with their partner and family. So it is something that we can help you with if you desire any help from Tan Law solicitors in maintaining the sponsor license, your system, and also in the visa application for your prospective employees. Someone is saying I heard about UK that it needs some drivers. Is it true? Yes. How to apply? That's what I was saying in a few minutes ago. Indeed, the UK is in need of haulage drivers or lorry drivers, and the government has announced that they are going to issue out about 5,000 visas or so, which will be valid until December, Christmas Eve. And then after that, we don't know what they are going to do. As to the nitty gritties, they've not yet said anything. It's still a skeleton, still needs a lot of flesh to be put to it. So we are just waiting. I've been checking since when they announced until now, unless if I'm missing the information, which I doubt. We do not know how this new visa scheme is going to operate for the haulage drivers, whether they're just going to be continued under the skilled worker, or it's going to be a specific appendix for the drivers, or maybe a concession for drivers. We do not know at the moment, but as they always say, watch this space. Someone is saying, I operate a train here in Mozambique. I don't have a license for it. I hope this is an opportunity for me to go to the UK. If this does not work, I don't mind Korora. That means I don't mind getting married even to your wife with 10 children. Okay, I'll comment on those 2 points. So if you want to come as an employee, you will come for as an employee of a company that has recruited you under their sponsor license. And if you are a train driver or a train operator, then if the train companies are recruiting for whatever they are recruiting, off my head, I don't think being a train operator is on the shortage list. If it is, then you have to operate to apply for a job under there. And then you speak about marriage. That's another route that people can use to come to the United Kingdom. If you get married to someone who is in the United Kingdom legally with even a limited leave to remain or settlement, or a British citizen, or an EU person with a settled status and so forth, you can come as a fiancé and married partner if you have been together for more than 2 years, or as a spouse, or as a same-sex partner, and so forth. So you need to meet the requirements of that visa, and then we can be able to come as a spouse, fiancé, and married partner, partner of a same-sex relationship and so forth. The major requirements will be to prove that the applicant is eligible to apply, the relationship exists, as can be proven by, say, a marriage certificate or utility bills linking you to the same address, and the applicant has passed the English test, has been tested for TB. The sponsor ordinarily should earn more than 18,600, unless, if, for example, they are under qualifying benefits or they are a pensioner on certain pensions, and things like that. And then there's also then to just so that there's accommodation where you can come and stay. Okay. Why does a certificate of sponsorship take so long to be issued? It's not only taking so long to be issued, there are also we have also noticed that the Home Office has added more requirements. They are now requiring more information than they used to require when they added, especially the youth and social care visa to the skilled worker list. Now they are demanding a lot more information from you and as an employer, even some information about your existing employees and so forth, which is now onerous. The reason why they are delaying, I think, is because of this requirement that they're requesting more information, and there's been an upsurge of applications being made for certificate of sponsorships, and the one that they always say is that there's COVID, or there was COVID, which caused a build up of cases. I was reading today that the Home Office intends to recruit more case workers because, especially for asylum cases, there's been now a large backlog of cases that needs to be decided, and the Home Office now wants to recruit more case workers so as to clear the backlog that is there. So I think Home Office doesn't have enough personnel at the moment. So the other question, I cannot really understand what they're saying. Just coming from Norway, just saying so solicitors can help to apply, or what are the requirements? I'm not so sure what requirements is this particular person asking about, but if you can be more specific, then I can try to respond to your question. Okay, there's a comment which is in Shona, but I'll try to translate it. Okay, I think the person is saying that if you want to get married here, and then the women, I think they're also busy in their own rights, or it's not necessarily to get married to get status in the United Kingdom. I don't want to think that's what the person is saying, but obviously every relationship needs to be genuine and subsisting, and it needs to be a durable relationship for I believe the Home Office to issue out leave to remain on the basis of a relationship. For people who are in the United Kingdom who have had applied for visas on the basis of relationship, if the Home Office does not believe your relationship, they will put your marriage notice on 70 days so that you can go to Liverpool and be interviewed. And in the interview, they will ask you questions which they believe that normal people in a relationship should know about each other. So you'll be interviewed and questioned separately in separate rooms. So the husband or one of the partners will be asked about the other partner, what you were doing, what they like, what clothes size are they, their shoe size, and so forth. And if there is any discrepancies in your answers, then the Home Office would say that your relationship is not genuine. So it's important to try to prove and to put evidence to show that your relationship is quite genuine when you make the applications based on on a relationship. Each visa application has got its own requirements, and the person asking about the requirements, you have to be specific about which visa you are talking about. A visitor's visa has got its own requirements, a spouse visa has got its own requirements, a student visa has got its own requirements, and so forth. So it's not always that all the visas will have the same requirements for you to be able to apply, because they are different. Okay. It seems that I do not have so many other questions coming in. So I will again comment on some things that are happening at the moment that are topical. We have also noticed that when applying for naturalization, there is also a delay. So when you're applying for naturalization in the United Kingdom, and if you want to avoid any delay, you might well consider, like another application, maybe paying an additional fee to the Home Office so that you can jump the queue. If you pay an additional 600 or 800 pounds, your decision will be made within 48 hours. And then if it's a limited leave to remain, then you have your biometric card within 10 working days. But if you pay the standard fee, if it's the limited leave to remain, the standard fee of £1,033, then your decision as it stands at the moment will be made 6 months or so from the date you submit your application. So if you are in a hurry to get your decision, it's better to pay the priority fee, although it's expensive, but it gives you peace of mind if you can afford it. What happens when an employer doesn't get their certificate of sponsorship on time? Can one apply with another? If the employer is not given a certificate of sponsorship, you are free to apply with another company if they're able to generate the certificate of sponsorship for you. It doesn't really matter. So you can move to another company if you want to move to another company. Even if you're employed by another company and you get a job with a different company, then you can be able to change your job. But also remember, apart from it being a visa issue, it's also an issue to deal with employment contract. You've got an employment contract with the current employer. So moving from them in terms of the employment terms and conditions might have its own consequences, which you might have to deal with. It might be restrictive against yourself, or it might be that you have to pay back any monies that were advanced to you, or any relocation fees or whatever. So you have to be careful before you want to move, and read the contract from your current employer of what it says before you move to another employer. What type of ELTS for Tier 2 for health and healthcare assistant? It is B1, so you need to do the B1 test. If for the English test from the senior carer or a support worker or nursing auxiliary category. Okay. Someone is saying that they work for an organization that has been awarded a sponsorship license. Okay, and they were not allocated any numbers to it. Yes, you have to go into the system, and then you can then request the numbers, or you have to justify the number and request the number within the system. So if you're just given a blanket sponsor license without any numbers, then you need to go into the system and apply. You can do it individually at a time. If you want a person at a time, you can do the application. Or if you've got a cluster or a group of people that you want to employ at the same time, then you can be able to apply for them through the system, the Home Office system. Can one apply for indefinite leave 6 months? Indefinite leave cannot be applied after you've been, maybe if you are saying that you've been in the UK for 6 months, then I don't think you can apply for indefinite leave to remain. Under normal circumstances, indefinite leave to remain ordinarily is after you've spent about 5 years or so on standard visas, and then you can apply for your indefinite leave to remain. And again, the requirements of the indefinite leave to remain will be different according to the type of visa that you were holding. So if you were, for example, on a spouse visa, then for you to go on indefinite leave to remain, you still need to show that the relationship is still there. The financial requirement has also been met, and you've passed the English test and so forth. So it will be after 5 years. If it's a refugee settlement, then you need to just show that you are still at risk if you were to be sent to your home country. If it's a refugee, you do not need to do the English test. You can just proceed and get your indefinite leave to remain, and it's free as well. I always warn people that are on that way on refugee or status that are on indefinite that it is counterproductive for you to visit your home country simply because you're saying you've got indefinite leave to remain. In fact, the Home Office now will write refugee settlement so that you cannot go to your home country, because that can be held against you by the Home Office. Or if you if you go back to your home country, or if you get a passport or a travel document of your home country, you are effectively revoking your own refugee status. So you need to be careful when you're in those circumstances. So indefinite leave to remain can only be gotten after you've spent ordinarily 5 years in the United Kingdom on uh, most of the limited leave to remain routes that lead to indefinite leave to remain. And some people that have got short courses on academic short courses, some of the period might not count towards indefinite leave to remain. So you need to, if you want to go on the 10-year route for indefinite leave to remain, you need to be careful on the courses that you do. Some of the period might not count towards the indefinite leave to remain period. Someone is saying that their mother have got an indefinite leave to remain, which was obtained when they were 18 years. That is the person typing the question. And they always say it can benefit the person who is now over 18. Indefinite leave to remain, like I said, it will depend on your time that you've spent in the United Kingdom. So if your parent had indefinite leave to remain and you came to the United Kingdom, um, the Home Office sometimes would have issued you an indefinite leave to remain, or would have given you 2.5 years. Then you need to do another 2.5 years, and then you'll get your own indefinite leave to remain. But if they're your parent, whether British or indefinite leave to remain or any visa, um, is in the United Kingdom and you are outside the country, and that indefinite was granted when you were under 18, it won't assist you much now that you are an adult, unless if there is exceptional circumstances or your relationship goes beyond mere emotional ties. That's when maybe they might consider someone of 18 years to be granted a visa on the basis of an adult relationship with their parent or an adult person. So um, that's the question to the person who is asking about their parent who was granted indefinite leave to remain when they were 18 years, and unfortunately, you won't be able to benefit much from those circumstances. Okay. I will give time to just answer one more question, and then we'll come to the end of today's program. So I think it's someone asking about a sponsor license again. Once we have a candidate, what do they Sorry, that is moved up. Once we have a candidate, what do they need to qualify to enter? Well, I think your question is putting the cart after the horse, because for you to get a candidate, you should have looked at what exactly, as an employer, are you looking at, because you can't get any candidate before you have done a job interview and you're satisfied with their requirements in terms of the job and indeed in terms of the home office requirements, because the home office requirements for a candidate to enter the United Kingdom are, for example, that they've passed their English test, they've done the TB test, they've had maintenance money in their account for 28 days prior to applying, unless if the employer is going to sponsor them, and they can also bring their family and so forth. So all those things are from the home office perspective. However, from an employer point of view, you need to look at what I've advised so many people, whether that person has got relevant and requisite qualification. There's no qualification mentioned by the home office when it comes to the carers or the support workers, but in the UK, there's, I think, minimum standards that are expected. For example, there's some mandatory trainings that they need to do. They have to be DBS, which is the equivalent police check required by the Home Office, and if possible, having some kind of experience with the type of job that they're going to do. If someone is going to work in a specialist area, maybe you work with people that have got a certain type of disability and you know nothing about it, then it's very difficult to justify it unless if you're going to receive some specific trainings for that particular specialization. So I think that question can be answered by saying that as an employer, you have to look at what is your standard job description and person specification for that job, and then you look at the home office requirements as well. Okay, can you clear something to me? Is UK recruiting HVG drivers from Africa, or it's only EU drivers? It's not yet so clear whether they will take drivers from all over the world or they will take drivers from EU. My suspicion is that they are aiming to get drivers from EU, but the message is coming from EU is that they don't think they'll be bothered to come to the United Kingdom when the United Kingdom is saying by Christmas Eve you should leave. So the visas are valid until Christmas Eve. So it's only October, November, December, and then the visa comes to an end. From what I've heard so far, I suspect that they are aiming people from EU. Whether the EU drivers will come for 2.5 months or so and leave their jobs, which they are doing in Europe, I'm not so sure. And the government has not yet clarified who exactly they are aiming or who are they targeting. The guidance is not yet out, and there is no specific provision that has been put in the immigration rules relating to this. So I think maybe someone is busy drafting these things as we talk. And in relation to that, I've also been contacted by people who are in the United Kingdom who were in the transport industry in their own countries. And maybe they are here illegally, or they do not have the requisite stay in the United Kingdom, but they've got the experience as HVG drivers. Again, we don't have a specific guidance from the Home Office, but under normal circumstances, if someone is illegally in the country and they want to work, and the Home Office would ordinarily want them to leave the country and make the application from outside the country to come to the United Kingdom. So that they might say that, or maybe since there is dire need for drivers, I don't know if they are going to bypass that need for people who will not have any legal leave to remain in the United Kingdom at all. but I'm getting those questions and from people who obviously are drivers or were operating their own transport businesses in their own home countries and who want to come to the United Kingdom or are already in the United Kingdom. For how long can I reapply after a refusal? Ordinarily, if you have been refused, you need to apply uh, anytime. You can apply if you're going to reapply to the Home Office. You can apply anytime. All you need, but if you leave it late, you are risking yourself being detained by the Home Office and maybe being removed or deported from the United Kingdom. If you were giving a right of appeal, normally, if you are within the United Kingdom, you can appeal within 14 days. If you're outside the United Kingdom, you can appeal within 28 days. If you were given a decision without a right of appeal, you might consider doing a judicial review, and you've got up to 3 months to submit your judicial review to the court. Otherwise, you will lose the right for the judicial review. And if it's administrative review, off my head, I think it should be 14 days to submit your administrative review to challenge any decision. So reapplication can be done anytime. And if you reapply, if you were refused an application by the Home Office and you reapply, uh, within 14 days, then you will be granted, if you are granted or whatever it is, if you reapply within 14 days of a refusal, then the Home Office will not say that you delayed because you have taken action within the 14 days. But after the 14 days, then you might lose the days that or the period that you might have accrued before because you would have broken the continual living that would have done in the United Kingdom. Another question is, are they revoking British citizenships for no reason? No, they will not revoke a British citizenship for no reason. They will revoke a British citizen under very rare circumstances, like, for example, it's for state security or public interest, or there's been some deceit in obtaining that British citizenship, but there has to be a reason, and it's quite onerous on the part of the Secretary of State to remove your citizenship. So there has to be a reason. They can't just remove it for no reason at all. Okay. Thank you so much for watching. All of our videos are on YouTube, so you can go and recap on YouTube. Or if you've got any questions, you can WhatsApp us, or you can call us or email us, and then we should be able to assist as much as we can. Thank you so much, and I'll be with you again next week.